Welcome back to this course on copyright and related rights law. In this week, we are discussing the subject matter of dramatic work in copyright and related rights law. In the previous session, we looked at the definition of dramatic work in various copyright acts in different countries. What we had observed in these definitions was that apart from providing some examples of subject matters which can be categorized as dramatic works, the definition also excluded cinematograph films. But what we also saw was that dramatic works such as choreography is capable of being written, and if it can in fact be written, how is it any different from literary work? This foundational distinction is something that we will discuss today and in the next session. Consider this image. What do you see? You see a person using a pen and who is going to write. What we had seen in the previous session was that when considering the term writing, we can possibly imagine a broader application, such as the use of not just words but also symbols. And if we consider it so, then notations could be written. In saying so, can a work of dance be written? Or in other words, can a choreography be written? If we break down the term choreography, we see that choreography is formed of two parts. The first part is a reference to the word chorea, which is a Greek term meaning dancing in unison, and the term graphy, which means writing. Together, it should mean dance writing. The fact that dance is nothing but a sequence of steps which have come together. What if these sequence of steps were written prior to its performance? We had seen that in cases of dances such as ballet, such is the level of clarity that performers need in order to dance in unison, there has to be a lot of practice, and such practice must be based on a predetermined choreography. And therefore, systems such as Laban system or the Benesh system, which are systems of dance or systems of works of dance, provide for a manner of representing dance in written form, notationally representing or graphically representing through lines, for example, on a similar format such as the format that we had seen for graphical notations in musical works, is an attempt to fixate choreography in order to bring in clarity for performers who are looking to replicate those sequence of steps. But if a work of dance is something that can be performed, can a literary work be performed as well? Since we are considering commonalities between literary work and dramatic work, we are seeing that the Benesh system and the Laban system seem to be systems which are favoring writings. But if the dramatic work which can be written is being performed in the form of a dance, is that also something that is happening with literary works? If yes, then is there really any difference between literary works and dramatic works? For instance, when a person sings, the lyrics that are being used, are those lyrics dramatic works or are they literary works? Let us look at what the Indian Copyright Act in section 14 provides as copyrights with respect to literary works. It says, for the purposes of this act, copyright means the exclusive right subject to the provisions of this act to do or authorize the doing of any of the following acts in respect of a work or any substantial part thereof, namely, in the case of a literary work, to perform the work in public. The question that we were looking to answer is whether literary works can be performed. What we have seen in section 14 is that just like dramatic works, literary works too can be performed. What is then the distinction between literary works and dramatic works? When we started this discussion, we focused on the question of whether a dramatic work can be written. You see, now we are at a point where performance, which we were considering as being central to dramatic work, is something that is also common between literary work and dramatic work. Early copyright statutes, in fact, protected dramatic works as literary works, similar to how musical works were protected as literary works. In a case that comes from the UK, Norosian versus Arcs, it was stated, the expression dramatic work is at large and should therefore be given its natural and ordinary meaning, which is that it is a work of action, with or without words or music, which is capable of being performed before an audience. What this tells us is that the purpose of literary works, where it is informative value or to dissemination of information or instruction, the purpose of dramatic work is to encourage performance, and not just any performance, performance of action. Is that the point at which we distinguish dramatic works from literary works? If yes, then perhaps we can say that a literary work can be performed with the use of words but no action. But for dramatic works, a performance would require some kind of an action. Therefore, look at this question and try to answer it. Are lyrics a dramatic work? You would note that when a singer is looking to sing the lyrics, there is no action component that is required. A singer can sing simply by using his voice. The action component is in fact an additional component which is technically not required for singing the lyrics in itself. And therefore, lyrics do not seem to be getting covered within our preliminary understanding of what a dramatic work is. Rather, lyrics seem to be falling within the ambit of literary works. Take a look at this image. You can see this person performing a handstand, quite a difficult exercise routine. But can exercise routines, from the mere fact that they are action oriented, can they amount to dramatic works? In other words, if the sequence of exercises can be fixated in some form, because they are action oriented in terms of their presentation. Will such fixated form be considered a dramatic work? What would the repercussions of such a dramatic work protection be? Would it extend to preventing people from exercising? Think of another such complex issue, an issue that arises in sports. The fact that sporting activity is also action oriented. Is it possible to relate it to a work of sports similar to a work of dance or a work of mime? What about stunting? Is it right to call it a work of stunt? So, this person who is engaged in an adventurous routine with his motorcycle, is he in fact performing some kind of a dramatic work? These interesting questions are something we will look at in a lot of detail, and hopefully through our understanding of this particular case that came before the Delhi High Court, we will be in a position to answer. This is Institute for Inner Studies versus Charlotte Anderson, in which the Delhi High Court was looking to analyze whether a claim towards the subsistence of literary work or dramatic work protection on books written on the ancient science of pranic healing and the exercise routines which were being claimed as dramatic works, would such subject matter classifications in fact apply? What we will see in this judgment is how the court is explaining what the literary work component in such a scenario would be and what the dramatic work component would be. Through this, we will be able to answer difficult questions such as the ones we are looking to answer here. According to the claimant, he says that he has adapted and systematized ancient science of pranic healing. There is copyright in the material stated in the books, and there is copyright in the performance. Now, what are the possible works where the exercises are compiled? Can we say that the compilation, because of its selection and arrangement, is a literary work? Can we say that the exercise routines, because they are predetermined and they are fixated, can we say that this is a choreography? The judge, Justice Manmohan Singh, points to the fact that there are some unsolved questions relating to literary work in the Copyright Act. What are these unsolved questions? Whether the performance of the work in public in relation to literary work would include merely a recitation of the work in the cases of the literary work in public, or in the alternative, performance of the entire facts or narration stated in the literary work in public in the form of performance by action or otherwise. To this, there is no clarity in terms of the act itself. Second, whether there are any exceptions to the said right of the performance of the work in the public in relation to literary work, or whether all the literary works enjoy similar level of protection which give the owner of the copyright an exclusive right to perform the literary work in public in any manner, including right to restrain the implementation of the facts stated in the literary work under the guise of the performance of the work in public. According to Justice Manmohan Singh, in providing that literary work authors have the copyright of performing the work in public, does not explain what would constitute such a copyright. Would it be the mere restriction of the recitation? Or would it be also some kind of restriction on the content in terms of the facts as is stated here? Can the facts themselves be brought within the ambit of the copyright protection? And would any kind of literary work be covered within the ambit of Section 14? Or will there be some kinds of expressions that are falling outside the scope of Section 14? Justice Manmohan Singh refers to Eastern Books versus D.B. Modak, a very important Supreme Court decision, which we will be looking at in much more detail when we consider the question of the interpretation of originality. But for now, let's look at this specific excerpt. It says, although for establishing a copyright, the creativity standard applies, is not that something must be novel or non-obvious, but some amount of creativity in the work to claim a copyright is required. It does require a minimal degree of creativity. This is in reference to how an expression would attain subsistence of copyright. When we had looked at the University of London versus University Tutorial Press case, we looked at how an expression must objectively be categorized as a literary work, and then such literary work must be considered on the anvil of originality. According to the Supreme Court, this is a subjective assessment which must bring in the question of whether there is any creativity that has been satisfied by such expression. Next, the court also looks at R.G. Anand versus Deluxe Films, another Supreme Court decision, a decision that we have discussed earlier as well, wherein it was said that there can be no copyright in an idea, subject matter, themes, plots, or historical or legendary facts, and violation of the copyright in such cases is confined to the form, manner, and arrangement and expression of the idea by title author of the copyrighted work. In our previous discussions, we have attempted to make a distinction between copyrightable expression and the underlying event, the underlying fact, or the underlying idea, something to which copyright doesn't extend. Where, however, the question is of the violation of the copyright of a stage play by a film producer or a director, the task of a plaintiff becomes more difficult to prove piracy. Why is this the case? The court explains, it is manifest that unlike a stage play, a film has a much broader perspective, wider field, and a bigger background, where the defendants can, by introducing a variety of incidents, give a color and complexion different from the manner in which the copyrighted work has expressed the idea. Even so, if the viewer, after seeing the film, gets a totality of impression that the film is, by and large, a copy of the original play, violation of the copyright may be said to be proved. In this image, you can see a representation of an idea. But you can also see that the representation is a distinctive expression for what we will perceive as an idea. You will now be able to answer any query on a distinction between expression and idea. In the present case, we see that the claimant is looking to prevent the implementation of facts and narrations stated in the book, which are asanas of yoga, on the premise that the said facts and narrations, descriptions of asanas and techniques stated in books authored by master, are his copyright, and thus the performance of the said works in physical form actions or performing such pranic healing yoga asanas must result in copyright infringement. Can this happen? Can the copyright expression extend to preventing what the expression is representing? Can it happen? I'm sure all of you are now saying that this cannot happen. Copyright cannot prevent someone from performing a particular asana on account of the mere fact that there has been an expression on that asana in a written form, because copyright doesn't extend to such matters. The court also explains that for the unwary who is not very clear with the distinction between idea and expression and the scope of copyright protection, which is limited to expressions, on first blush, the argument is actually convincing that considering the provisions of the Act and in the manner they are worded so as to include the performance of the work in public. But once the said argument is tested from the glasses of idea expression distinction, which sometimes the courts have to make in a given case, the answer becomes clearer and the shadow of doubt which exists in the mind proceeds to obliterate. With this, we have formed a foundational understanding of the manner in which literary work must be considered in terms of performance. In the next session, we will look at this case in some more detail in terms of both the literary work and the dramatic work component. And with that, we will be able to answer some complex questions on how these two are different. Thank you for joining me. See you in the next session. Thank you.